The first order of business is a joint telephone conference meeting with the Montgomery County Planning Board. So it'll be a meeting of the full commission, Maryland National Capital Park and Planning Commission. So who's here?
Somebody calling?
You can finish right, because I have half an hour before we get to that.
Followed by the pound sign. I could die.
Welcome to the conferencing center. At any time during this message, please enter your passcode followed by the Your passcode has been confirmed. If you need technical assistance during your call, press *0. After the tone, please state your name, followed by the pound sign.
Prince George's Planning Board.
Thank you. There are 4 parties in conference, including you.
I need to know which Prince George's commissioners are present so we can verify that we have a quorum and start the conversation. Can any of the Prince George's board members hear me?
We are here. We have with us Vice Chair Dorothy Bailey, Commissioner Will Dorner, and myself, Elizabeth.
Oh,
Healy.
okay, great. Good morning to all of you.
Good morning.
And we've got over here all 5 Montgomery commissioners.
Okay. Good morning.
So with that, I'm going to turn it over to Carol Rubin to brief us on the on HB 1249 and HB 1424.
Good morning, Carol Rubin for the record. I had understand that at the commission meeting, the full commission meeting, the General Counsel Gardner indicated that you all had approved or had support with amendments to 2 bills that impact the P3 for the 495-270 Managed Lanes project. One just generally the P3. There's House Bill 1249, which we're going to call the Promises Act, and that is, well, they've named it the Promises Act, and that deals with specific to commitments that the legislature is looking for in the agreements that are going to be entered into for the Managed Lanes project. The other HB 1424 are some changes generally to the P3 Act for the state, so it would impact any P3. So you would ask that we come back and be clear with what the amendments are that we're going to propose. I might want to add as a start that Montgomery County, the County Council has voted to support the Promises Act, HB 1249, as written. And there are a few things tweaks that we think would make it better. And the idea is that we can go and talk to the sponsor to try to improve that bill for two ways. One is those things that are within our purview, those that affect the commission specifically, and then there are some things that are outside our purview, and we could make them as suggestions that we think would improve the bill generally for the community, for the residents of Montgomery and Prince George's County. So Deborah and I prepared a staff report that we listed generally with those things first that are within the purview, our purview, and those that are not. So I'm going to go over those briefly, and then if there's any specific questions about what those amendments, about each one, we'll be happy. Deborah and I will be happy to take those questions. So the first one, and this is in no order of priority. It's just we did it in order of the bill as written. So the first one is that we would want to specifically require that the P3 private entity come in for a mandatory referral as each segment of the highway is designed, is engineered and designed at a 30% plan, because normally that's what they do for construction. They will be coming in for a mandatory referral on the preferred alternative, we want to make it very clear that that's just step one in the mandatory referral act or requirements. The second thing is that we wanted to make sure that the mitigation plan that they do come up with, the State Highway comes up with, is, as you're aware, the law requires on 404 parkland replacement, it requires first that they avoid, if avoidance is impossible or they can't find an avoidance technique that's reasonable, and I say reasonable within the standard of the purpose and need, that's the way they define it in the law, then they would go to minimization and then mitigation. And we understand that the proposal, as I think we're moving forward on the DEIS, is probably going to say that the Maryland 200 alternative is not a reasonable diversion alternative or reasonable avoidance technique for purposes of staying off of 495, the top side of 495. And at a staff level, from a technical review, because we haven't received all the data on the origin and destination, we've received some reports, but not really the complete data. We're not convinced. And then the way they modeled it, with adding a part of 95, we're not convinced that really they've looked at it fully and properly to determine whether it's enough of an avoidance technique. So we want to elevate the standard to make it very clear. So we think that is a important part of adding to the legislation, that they can't just go with what the minimum amount of analysis that they've done. The third is I'm gonna talk to points 3 and 4 together. The way the legislation is written now, it does indicate that there is a pedestrian and bicycle path that has to be included in the design of the American Legion Bridge. There's also a provision in the legislation as proposed that requires MDOT to engage Virginia to conduct a study of the American Legion Bridge corridor. So what we'd like to do is take those two and combine them in a way that requires not only that pedestrian and bicycle be accommodated on the American Legion Bridge, but rail. We want to make sure that it is designed structurally to accommodate rail, similar to what they've done with the Woodrow Wilson Bridge. And then we think that it makes more sense to have MDOT engage Virginia in a discussion of both the American Legion Bridge and the Woodrow Wilson Bridge corridors to determine how to tie rail in for potential future transit. So we'd like to add add that and so it beefs it up a bit. We want to clarify another point. I'd like to clarify that as it is, the Board of Public Works indicated and the law indicates that state funds cannot be used for acquisition of land prior to approval of the P3 agreement. Because we're having a difficult time with the mitigation plan that's being discussed, we'd like to clarify that that doesn't mean option payments. In other words, they can't acquire the property, but they could use state funds potentially to enter into option agreements so that if there's land that they want to provide as mitigation, they can get it under kind of an option agreement for future acquisition if in fact that's a possibility. So
Okay.
that it's just a clarification point.
And Carol, can I jump in just a minute for Carol? This is really important to us because SHA is using the fact that they can't acquire land as an excuse to tell us that they cannot really engage with us in a mitigation discussion because they can't make any determinations about acquiring land for the purpose of mitigation. And so they're basically putting us off and at the same time talking about doing mitigation in other counties as opposed to doing the mitigation where it needs to be, within these watersheds, within, the areas of impact. So, they're using this situation as a way of putting us off on the mitigation. So this is actually deceptively important to us because, we're getting stonewalled on this mitigation issue, both of us, both sides.
Yeah, I don't, and as Deborah said, it's difficult. I don't know that it's intentional. They're concerned that they can only use what is now state-owned property to substitute or to mitigate for the parkland that would be necessary for this project. And they don't have very much state-owned land available to do that, and that's why it's created a problem. And then the final point, again, I'll take 6 and 7 together, that was in the staff report. It has to do with the requirement that MDOT share data with the county and with the commission. We think that's important, but we also think that it's covered under the MPIA. The concerns that we have about that and the way it's written is, number one, it limits it to certain data, and we don't want them to consider that, oh, maybe we don't have to provide other data, that we only have to provide what's there. We want to make it either broader to require it, and we also want to tighten, close a loophole in the way it's written, unintended, I believe, but it says that if they could avoid, potentially they could avoid disclosure and data sharing if they consider it confidential. And our position is enter into a non-disclosure agreement, but don't say that, so we're looking to tighten up that, close that loophole, potential loophole. And then those are the things that really have direct bearing on the commission and our relationship on this agreement. The other items are really dealing more with support. So let me take your questions, if you want, on these particular items first. And also, Deborah, take any questions that other people have over in Prince George's. And then we can talk about the others if you want, but it's listed in they're listed in the report, so.
Just real quick, before we go to the questions, I just want to emphasize on the Prince George's side, the Woodrow Wilson Bridge piece in number 4 is also very important because the bridge has already been reinforced for rail. By them leaving it out in terms of that they're going to say that they're going to study the American Legion Bridge for bike ped, but they're not going to say that they're going to study the Woodrow Wilson Bridge for rail when we've already, as a state, spent money to reinforce that bridge. It doesn't make sense. So we're really pushing on that because, the only way we're ever going to get that rail across the bridge is to go in incremental steps. You've got to do a study here, and now you've got to push to get the funding to do design, et cetera. So we know this is a small step, but it's an important step because otherwise we're never going to get rail to National Harbor. National Harbor was built, with the premise that there will be some sort of transit in the future there. And here we are almost 30 years later, and there's no transit. So we are really pushing that, and that's the genesis of that, because money has already been spent. So the least you could do is include a requirement that you've got to study it as part of this, these phases of studies that are going to be done. Okay.
Okay, I think I want to recognize Prince George's members first because I can't see them. So I rather than have them have to listen to us talk over them, I thought it might be better to let them go first with the question. Does anybody in Prince George's Commission have any questions?
Yes.
Yes.
So, Casey, can you hear me on your side? This is Will Dorner.
Yep, we can hear you.
Okay. So I just have a couple of questions. Some of them I think are kind of easier, and some of it's just because I haven't.
Pass it down because it's.
Yeah, it's
we have to
echoing.
echo or delay.
Okay, what on technology side? Okay. So on.
No.
Take it off speaker too.
Okay. On the first couple of questions or points in here that we were talking about with number 2. So we have defined in here the clause of the mitigation should be of equal or greater natural, cultural, or recreational value. So my concern is who decides that? And is this going to end up in litigation where we have a different opinion than what the state has on that? Are we going to do a dollar value? Is it going to be sort of a qualitative problem that could end up giving us a lot of sort of back and forth and heartburn? And then kind of tying it with that and I think it was number 5? Yeah, and number 5. If the state doesn't have land in this area, and regardless of if they don't have money at the point, the state legislature can always pass funding or shift it around. Would it be easier for us to say, okay, look, if you're not going to give us land because you don't have it in the watershed of this area, can we do some sort of a cash equivalent for either mitigation or actual taken parkland that we could purchase then on our end and sort of resolve that and keep it within the same watershed to have an actual nexus to the project itself? And I'll stop there. That's my first question.
Okay, so the first question about who determines equal or greater natural, cultural, recreational value, that is a determination that we would have to make as a commission, because we wouldn't agree to transfer property unless that determination, we could make that finding. That's a finding that the commissioners must make. And so we're making it clear by including it in the P3 legislation that same finding that has to be made anyway, because that's a finding that we have to make under our provisions of the land use article. That same finding is in the P3. It's more of a reinforcement. This is a finding that has to be made anyway, because we are not going to make that determination that we can give up parkland unless we can replace it with something equal or greater.
But wouldn't they have the legal authority? So wouldn't the state have the legal authority to, and I don't know how the home rule is in Maryland, to just take it from us, even though we are another state agency, since we're by county, wouldn't they just have the legal authority to do a takings and then they decide in a legal proceeding what would be the just market compensation for that? Or do we have to actually come to an agreement on that?
No, actually, our position is that that is not the case. The SHA could not take public land under their eminent domain legislation, because that legislation is specific to private land. They can take private property, but when it comes to public property going for another or a different public purpose, you have to follow the regulations concerning how you got the land in the first place. So under Capra-Crampton, we'd have to go through a federal process. No, you can't just decide that you don't want to go through that process because it's going to another public purpose. Same thing for parkland. We would have to follow our own statutes, and if we ended up in court, basically a judge would have to decide, have we followed our own regulations? It's not as if the state can just say, we're going to ignore these regulations because we need it for another public purpose. No, they can't do that. It's not the way it works.
So, but do we have case law within the state of Maryland or the U.S. Supreme Court? So I understand the distinction of public to public versus public to private. I don't know if there's actually been a lot of eminent domain takings for public to public at sort of what would be an equivalent state level. So if you're the state legislature taking from a local municipality who you've given the police powers to, then you can obviously always revoke that in certain states, depending on how home rule is treated. I don't know if there's a lot of distinction between, since we are a state agency technically, whether or not a state agency could take from another state agency through eminent domain, and then they would determine essentially the market value. Because that, in most eminent domain takings, it's a state agency that establishes the market value, and then there's a dispute about whether or not that actually is the market value.
Well, this is Casey Anderson. I think if you want to talk more about the legal basis of our position, we should do it in closed session. I think because you certainly would not want to be saying something on the record that suggested we did not have an airtight argument on this point or others. I think it's fair to say that this same issue arose in the context of the ICC, and the state accepted our position. They have occasionally asserted that they have the power to take our land, but we feel like we have a very strong statutory basis to reject that. But again, if you want to get into it further, I think we should take that offline.
Okay, yeah, I think we should discuss that, and to the extent that we need a footnoted or anything else to bolster our opinions, we probably should later on.
We are absolutely prepared to do that, and if we need to schedule a closed session to get into that more detail, we will do that.
That would make me feel more comfortable in terms of making sure we're totally airtight on this.
Absolutely. No, we can't do it right now. We would have to schedule it and notice it properly.
Okay, and then I would also just like to have somewhere in there, since we are talking about the watershed, to make sure that we do include a clause about within the watershed of either county, whatever county we're talking about. to make sure it's very specific that they cannot exchange land in Howard County or somewhere else that is supposed to be for mitigation of what's in Prince George's or Montgomery County. And then the last question on here with the MPIA, I haven't read it for number 6, so I don't, or maybe we got it a long time ago, and I have, but I don't recall specifically the data sharing agreements within there. So I just wanted to clarify, does it require them to share, or does it just provide a mechanism for us to allow sharing? Because they could say that something is confidential, or they could also just say they don't want to share it with us. And I want to make sure that we don't sort of, by eliminating that clause, we don't back ourselves into a problem where they later on say it's either confidential or they just don't want to give it to us because they just don't want to cooperate with us.
Well, the problem that we see is that they are calling out specific documents that they are saying you are required to share. And we're concerned that if they don't specify everything, that anything that they leave out of the list, SHA will say, well, it's not in the list. We don't have to give it to you. That's what we're concerned about. It's not a comprehensive list. And so unless you're going to literally go in and list everything that could possibly, be needed by us, why not just rely on the MPIA and say, you got to follow the MPIA, and you've got to, release documents that are public documents. Because, we're just concerned about the whole, missing items off of the list. We're concerned about the language that says that unless it's confidential, because they'll just say everything's confidential, which is kind of what they've been doing now. And so, we think the MPIA is pretty clear about what is and is not confidential, and we don't think any of these items that we're asking for actually are. But even if they are, we're a government agency. Why can't we just do an NDA and call it a day and give us the documents? And we will promise not to release them.
Sorry.
Okay.
What we could do is, I think what we're going to do is suggest that simply it refers to that the language in the legislation refers to the MPIA, but has a clarification statement that if it is considered confidential, that we would enter. It would simply take a non-disclosure agreement between the government bodies to allow release of that information under the MPIA.
Right, which is something they could have done already, but they haven't. And so, that's why we're saying, put it in the legislation and make them do it.
Would it be, so I like, Carol, I like that suggestion. Would it be better just to leave those things in there, though, and just clarify that we're not eliminating anything that would otherwise fall under the MPIA, just to actually call out the specific provisions that we want to be very publicly open about wanting to have and having this sharing agreement, but then that this document itself doesn't actually limit what would also be agreed upon or be able to be shared in the MPIA? Because I'm just afraid that if we pull this out, then they can just fall back on the MPIA, which may not be as strong of a document in enforcement purposes. But if we actually have a couple of clauses in there about specific data provisions that we want to be shared, and then have something else about, but we're not limiting it only to those, we at least emphasize that we absolutely have to have those shared, and that everything else kind of falls in on the MPIA.
That could be an alternative. I mean, I think one of the things that we didn't want to do was get into specific language today in our discussion, because we haven't approached the sponsor yet, and we believe that this is a negotiation for language, and what we wanted to talk about it as far as the concepts that we're trying to accomplish. And so that is an alternative we can look at, is just expanding the list, making it very broad, or not having a list, but say anything that would be covered under the MPIA, and any confidential information would be disclosable with a non-disclosure agreement. I think that could do it. If I'm a little bit concerned about having a list of any documents that are specific because of certain statutory construction.
Yeah, I'm fine with that concern. I'm just, and I would like to have sort of just the et al clause. I think that would be a better approach, because we've already had difficulty with them not sharing transportation numbers and other data with us. And by specifically saying you have to do these, and then everything else is kind of covered by the MPIA, I think that gives us a stronger argument publicly an endorsement from the state legislature to actually get those documents, rather than us having to go back to the MPIA and just bicker back and forth with them because they don't consider that they have to actually agree with us. I think that actually calls out at least a few specific things. And if you want to clean up how the confidentiality thing is referred to in there, that would be good, but it'll definitely hold them a little bit to the fire a little bit more.
Okay, we'll take that. We'll keep that as an alternative for language.
This is Betty Hewlett. I think the concerns raised regarding item 6 in the MPIA are critical. I'm not wedded to how you do it, so long as we do it in the most effective way that protect our rights to get it. And I think and if you need to use it as a negotiation tool, then that's fine. So long as we, can get to an NDA. And I think that I do understand that by enumerating the specific items that we would want released, then it could give the impression that was all-inclusive, and that's what we want to avoid. So I think either the language as proposed by Commissioner Dorner to say that it's not all-inclusive, or to not include that language in at all, to not include any of the specifics in there at all, provided that you use that as a negotiation tool, might be better. But at some point, if you use that as a negotiation tool, at some point it has to be addressed. And that's what I want to make sure. And if we do it pursuant to a non-disclosure agreement, that would be great. I don't think we have any other questions here on the side.
No more?
No.
Or are there more?
No.
Do we have any on our side? Jerry? Thank you. I'm on Circle 7 of the bill. It's page 3 of the bill. And a couple of questions that did come up, the Woodrow Wilson Bridge in particular. There is a federal highway requirement called the 3C process, which is a comprehensive plan, continuing and coordinated plan for the region. So again, for the region to perhaps identify, consistent with the Woodrow Wilson Bridge, the provisions for transit on there. Could be also say, this is a region, we have a beltway, federally funded. This is a U.S. DOT federal highway requirement to have a comprehensive plan. So the comprehensive plan could say there would be transit, some element of transit on the on the American Legion Bridge as well. So it would provide a comprehensive and coordinated plan for the region. And I think that could be used by the state and could be used by the local jurisdiction, Prince George's, Montgomery, and Virginia. I'm very pleased to see the idea of a pedestrian walkway and bridges. It really does link the trails in the Potomac River Valley there, and I think that's very important. The other thing that we did have in Montgomery County, I don't know if we still have it, MC, was quick take. As long as there was not a livable structure involved, we actually assisted WSSC and we assisted State Highway in getting right-of-way for projects where we had quick take. I don't know whether State Highway has it now. They didn't at the time. But again, it's possible that the county, Prince George's or Montgomery, could acquire property and then be compensated. Just a thought. Maybe not. Could be compensated back by the state.
Yeah, the state does have quick take for at the same level as the county does.
Okay. And the other thing we did, for instance, we got through the Camper-Compton provisions on the Great Seneca Highway. We were able to negotiate that with the Department of Interior, National Park Service. There was state property there, park property, and federal property. And again, that road has been transferred, I believe, to the state. So kind of a quid pro quo, not necessarily using that term, but we could do something with our quick take provisions or other properties that we have to maybe trade with to acquire it and then be compensated by the state for projects. The other thing, too, is that would be an option that I see. Again, I recall the Sierra Club thought Woodrow Wilson Bridge would
should be a tunnel. But again, the compromise to say transit is accommodated, I think you really engender more support from the community. As things change, you can see that we're moving to transit facilities, and doing that on the American Legion Bridge really makes the project more acceptable to the public. The other point would be in number 4, which talks about community benefit agreement. I've kind of advocated for what I call a community benefit payment. I worked on the US 29 busway with Rob Klein from MCDOT. One of the things we suggested was a community benefit payment in the event that some property was really needed, occupied house or something, that those purchases could include a additional benefit payment because they're supporting a community effort, and that could be 25% or something that would go to that property owner. I see that where noise is severe presently, those people could be, their homes could be needed for the project, they could be acquired, but again, under that community benefit payment or agreement, they could get an additional compensation above and beyond fair market value. So whether that requires legislation or just kind of a something that could be done by state DOT, state highway. A couple of thoughts on that.
Okay.
Done. Yep, thank you.
Go ahead.
Thank you for being here, Carol. Is there anything on these bills to talk about CSX pushing us? Because I see the monorail, why not? I mean, if this attempt is to ensure that there's less traffic in 270, CSX having the third track, as we debated and discussed in past in the Mark Rail Master Plan that we just approved last year, none of that is here. And to me, I don't want to say that I'm against wanting the Beltway, but I am. And the fact that we don't have anything on CSX, I think we're missing the point.
Okay, so there's other legislation that's in front of the state that I believe Delegate Solomon introduced.
It's not one of them.
It's not part of this. It's a different bill that requires that MDOT and talk to CSX about extending their service beyond the Union Station into Virginia. And one of the comments that we had made about that is they should also require, it's an engagement requirement that they engage in those discussions. And one of the things that I believe that Adrian is working on is to get them to add to that something about adding negotiations for expanding service in Montgomery County. But if, the question is whether that can be incorporated into this same legislation, we can take that up. One of the things that obviously we would be concerned with is bulking this legislation down so much that it then doesn't pass. So, but we'll raise that. Obviously, Deborah and I are going to provide Adrian with all the comments that you all have made. We will add that to this and see how his thought is, whether he wants to see if he can incorporate that legislation together with this. But I understand exactly what you're saying.
I'm not judging you or anything. It's not just a comment. If we're really serious about making sure that we have less traffic in this county, then we gotta be serious. And being serious is actually investing on trains, on rail. And if we don't have, you have the monorail here. So when you talk to the sponsors, you have the monorail feasibility study. Why not saying you must require to have a conversation, a serious conversation with CA?
Yeah, I hear you on that.
Yeah.
Yes.
So
I was just, I didn't mean to say that I was putting it aside. I was just that there is other legislation that deals with that issue.
Should be here.
But the question is if we should bring them together, and that's
At least that's my position. I don't know how
absolutely
you feel.
okay.
Prince George's, I'm assuming they will also agree.
I like monorails. I've been watching The Simpsons for years, and I love the idea.
It's fine. We're okay.
One's maglev, so.
Well, I don't.
Does anybody feel the need, it's in the report, does anybody feel the need to go over those things that are outside our purview? It really just tightens up the law a little bit, in interest of time.
I think that's fine. Is there
Okay.
anybody else?
We're good.
No, okay, hearing no other commissioners wanting to make a comment or ask a question, I think we can look for a motion to approve our comments and express our support for these two bills
I so move. This is Betty Hewlett.
via our lawyers.
Second. Somebody move over there.
Somebody made it?
Yes, I think it was Betty. She
Yes.
moved, right?
Yes, that's
And then
correct.
I second.
And Natalie seconded. All in favor?
Aye.
Opposed? Approved. And we're adjourning our special Tri-County meeting.
Thank
Going
you.
back to our regular scheduled program.
Thank you.
Thank you, guys.
Thank you. Thank you, Deborah, for your work. Okay, having concluded our special Maryland National Capital Park and Planning Commission meeting via teleconference, we will now resume with the rest of our Prince George's County Planning Board agenda. And as always, before we proceed with our agenda, we start with a moment of silence for those who have passed on in the intervening week. So we're going to start with, in our commission family, we lost Laurie Verge, who passed away at age 76. She served as the director of the commission's Surratt House Museum in Clinton since 1983. She began working there in 1975 as a volunteer and was also a founding member of the Surratt Society. She was considered an iconic leader and leading authority in the Civil War, the assassination of President Lincoln, and local Southern Maryland history, because as you know, the Surratt House was owned and operated towards the end by Mary Surratt, who was the first woman hanged in Prince George's County, or in America actually, for her role in plotting the assassination of President Lincoln. So we own the museum, and Laurie Verge was the director of the museum since 1983. We want to remember her. We also want to remember Mildred, the inimitable Mildred Ridgely Gray, who passed away this week at the tender age of 99. I was at an event on Sunday at the Ridgely Rosenwald School where she received an award, except that she wasn't able to be there to get it. This was the first time ever, but her daughter accepted it on her behalf. Mildred Ridgely Gray was beautiful, feisty, intelligent, persistent, and yes, just pretty daggone amazing. So she was part of the Ridgely family, which for over 100 years, they were landowners in Prince George's County, right along the Central Avenue area, and they influenced the history, education, community, and land development on both sides of Central Avenue and Ritchie Road. They traded land. They partnered. So the Rosenwald School, the Ridgely Rosenwald School, is one of the 5,000 Rosenwald schools, more than 5,000 Rosenwald schools in southern United States, and one of the 27 Rosenwald schools in Prince George's County. It was a partnership between Julius Rosenwald and Booker T. Washington. So in this particular case, the Ridgely family traded land and donated land also to the Ridgely Rosenwald School. And so and they just celebrated their 93rd anniversary this year. So we want to remember Mildred Ridgely Gray, and who ultimately became a principal at school. She attended as a child, but ultimately became a principal. So we want to remember her. The museum is owned and operated by the Commission, and it's operated in conjunction with the Prince George's County Alumni Chapter of Delta Sigma Theta Sorority Incorporated. And also, I want to, in Prince George's County, we lost Jean Wicks, who was a professor at Bowie State University and a graduate of North Carolina A&T. And she was an active member of the National Conference of Negro Women and a host of other civic organizations. And she was a Golden Soror of the Alpha Kappa Alpha Sorority Incorporated. We want to remember the victims of the shooting of the in the Coors plant in Milwaukee, Wisconsin. 7 individuals who were shot. We want to remember Barbara Elaine Smith, otherwise known as B. Smith, restaurateur, model, lifestyle icon who succumbed to a battle with Alzheimer's. She was the first African-American woman to appear on the cover of Mademoiselle magazine and created a lifestyle empire to including cookbooks, weekly TV shows, home decor, and so much more. She opened 3 restaurants in the nation, and we want to remember her. Another brilliant woman, Katherine Johnson, who passed away at the age of 101. She was a brilliant, pioneering mathematician who broke barriers in space and in NASA. She worked for NASA for more than 3 decades, and she was known as one of the human computers depicted in the movie Hidden Figures. She was the first woman in NASA's predecessor, the National Advisory Committee for Aeronautics, to receive credit as author of a research report. She was best known for the work that greatly contributed to the first American orbital spaceflight piloted by John Glenn. She won 3 NASA Langley Research Center Special Achievement Awards, and she too was a member of the Alpha Kappa Alpha Sorority Incorporated, as is our vice chair. Zoe Caldwell, age 86, Broadway actress, won 4 Tony Awards, and she died from complications due to Parkinson's disease. Chietsu Watanabe, age 112, the world's oldest living man. He passed away in Japan. Clive Cussler, age 88, adventure novelist and creator of the recurring character Dirk Pitt, who was a globe-trotting adventurer. His book sold millions of copies. For those of you who may have suffered a loss of which I am unaware, I just want to extend our sympathy to each of you as well. If we can have that moment of silence. Thank you. Again, it's the month of February. It's Black History Month, Library Lovers Month, American Heart Month, National Teen Dating Violence Awareness Month. I've given statistics on teen dating violence already. It's just very prevalent, far more prevalent than you would think. It is also the 27th, February 27th, 1801, Washington, D.C. was placed under congressional jurisdiction. 1827, February 27th, 1827 was the very first Mardi Gras celebration in New Orleans. 1897 was the world-renowned virtuoso, a classical singer, Marian Anderson was born. And if you know the story of Marian Anderson, I mean, she was so immensely talented, and she was attempting to sing at the Constitution Hall in Washington, D.C., but the DAR, Daughters of the American Revolution, prohibited her from singing there. So I don't know what the capacity was at Constitution Hall, but after learning that she had been denied the right to sing there, a number of civil rights activists, along with the First Lady Eleanor Roosevelt and President Franklin Delano Roosevelt, said, okay, enough of that. We're going to have you sing on the steps of the Lincoln Memorial, where 75,000 people came to hear her sing. And that was so take that, Constitution Hall and DAR, and plus First Lady Eleanor Roosevelt relinquished her membership in DAR. But Marian Anderson was a renowned singer, just something to behold. 1922, the United States Supreme Court unanimously upholds the 19th Amendment granting women the right to vote. 1963, basketball great Mickey Mantle of the New York Yankees signed a $100,000 baseball contract, which was quite a lot in 57 years ago and nothing to sneeze at today in 2020. 1964, Anna Julia Cooper was a prominent African-American scholar who died at the age of 105. She was born into slavery and became a sociologist, author, black liberation activist, and she was the 4th African-American woman to receive a doctorate from the period, and in her case at the Sorbonne in Paris. She was sometimes referred to as the mother of black feminism, and she ultimately became a teacher and later principal at M Street High School, and which became Dunbar High School. and which was pretty renowned, and I will tell you, my mom went there. And finally, she too was a member of Alpha Kappa Alpha Sorority Incorporated. Okay. 1968, iconic CBS News anchor Walter Cronkite delivered a scathing editorial on America's chances of winning the Vietnam War. And then 1981, I'm just testing here, Paul McCartney and Stevie Wonder recorded what? Ebony and Ivory. Okay. So again, it is National Hot Breakfast Month, Great American Pie Month, and today, the 27th, is National Chili Day. Again, finally, we close out with census. Okay, Ryan, where's my census logo? We close out with census. We are going to be hearing this every single week, but it's imperative that everyone be counted for census in the decennial census this year, 2020. We lose $10,250 for each person not counted, and in Prince George's County in the 2010 census, that equated to a loss of $363 million that could have been used for education, for roads, for transportation, for social programs, and so many needs that we have in Prince George's County. Plus, we had amongst the highest undercount in the state of Maryland, and we were higher, our undercount was higher than the national average. We cannot afford that in Prince George's County. So please make sure that everyone is counted. We in Prince George's County are proud to be counted. And without further ado, we're going to proceed with our agenda. First order of business is is anyone here to oppose the staff's recommendations on items 4B, 4A, or 4D? Or any board member who wishes to discuss?
Madam Chair, I move adoption of the staff findings and approval of items on the consent agenda in accordance with the recommendation of staff.
Second.
We have a motion and a second. Is there any discussion? All in favor?
Aye.
Opposed? The ayes have it. We're going to proceed with items 5 and 6, which are companion cases, the detailed site plan and departure from design standards for Park Place, and then we will come back to the rest of 3A, which is legislation. Okay.
Good morning, Madam Chair, members of the board. For the record, I'm Jonathan Bush with the Urban Design Section, and I am presenting item 5 and 6, which is a DSP, DDS, and AC to develop 128,810,000 square feet of flexible industrial space to be used for office, warehouse, and distribution. As a matter of housekeeping, I would like to note that the staff report that's presented before you had an inaccurate planning board action limit date. The action limit date shown on your staff report is February the 13th. It should read February the 29th, 2020.
Thank you.
The site is in Planning Area 60, Council District 01. The subject property for Park Place is located on the south side of Muirkirk Road, approximately 650 feet west of its intersection with Virginia Manor Road. The property is zoned I-3 and is bounded to the north by public right-of-way of Muirkirk Road, with single-family dwellings in the planned industrial employment park, I-3 zone beyond, and to the east by I-3 zone property, developed with industrial uses. To the south by vacant, wooded property zoned open space and owned by Prince George's County government, and to the northwest by property zoned in the rural residential zones, developed with residential uses. This aerial shows the subject property, irregular in shape, outlined in red, and surrounding land uses to include the single-family dwellings to the north. The site sits near Maryland Route 200, the inter-county connector, as shown to the north, and presents an opportunity to reimagine the site and the vicinity as an emerging gateway into Prince George's County. The site includes topographical changes and environmental features on the property. Again, the property is outlined here in purple for your viewing. The property is situated on Muirkirk Road, which can be seen highlighted in blue. Conterra Drive is an arterial facility, and it's illustrated here in red. The bird's eye image shows an enlarged aerial of the existing property outlined in red. The existing single-family dwellings are shown here to the north, and the adjacent employment park is shown here to the east. The overall site plan shows the proposed 2 development pods, parking, and points of ingress and egress. The image also shows the 20 microbial retention facilities to treat the majority of stormwater before it leaves the site. The site plan proposes the construction of a 128,810 square feet flexible industrial office, warehouse, and wholesale trade uses on 2 proposed parcels. The western parcel includes 66,000 square feet of a 1-story flexible office warehouse building. The applicant has filed a departure from Section 27-558A of the zoning ordinance for a reduction in the standard parking space size to 18 feet by 9 feet. The eastern parcel includes a 62,810 square foot building proposed for a restaurant depot. The plan also shows 9,860 square feet of possible future restaurant depot office expansion along the northern elevation that will be subject to a future amendment to the detailed site plan. Access to the site is shown in 2 separate entrances in the northwest portion and northeast portion of the property along Muirkirk Road. The site plan does illustrate all improvements to, including landscaping, stormwater management, and generous parking facilities. The application includes all site design elements for the proposed developments and conforms to the zoning ordinance. Standard sidewalks are proposed along Muirkirk Road. This illustration provides a cross-section of Maryland Route 200, the intercounty connector, and its proximity to the proposed site. The application contains the required schedules, and also the applicant has filed an alternative compliance application for the requirements of Section 4.3 parking lot interior planting requirements. The alternative compliance application is recommended for approval by the planning director. The application has also requested a variance to the requirements of Section 27-465A of the zoning ordinance to allow a proposed retaining wall, highlighted here in pink, in excess of 6 feet high in the rear yard and the required setbacks. This illustration shows the tree canopy coverage found to be in conformance with the requirements, except for technical conditions contained in the staff report. Staff recommends approval of the specimen tree variance that is recommended for approval in support to remove 5 of the 11 specimen trees located on the site. Regulated environmental features and the associated impacts have found to be consistent with the preliminary plan of subdivision. The applicant introduces a high-quality building typology and varied materials displaying weight, light, and gravity. This image depicts the western partial, which proposes for flexible industrial office space, achieving a building height of 36 feet. A condition has been contained in this report to revise the general notes and elevations relative to the quantity of loading doors and personnel doors. This image depicts the eastern partial which proposes restaurant depot. The applicant introduces horizontal banding in the restaurant depot blue and black and horizontal banding along the water table. Staff notes that the applicant incorporated several strategies and supports the architecture as proposed. The photometric plan provides adequate lighting throughout the site and minimizes spillover or glare onto adjacent properties. And in closing, the DSP, DDS, and AC was found in conformance with the requirements of the zoning ordinance, the landscape manual, the Woodland and Wildlife Habitat Conservation and Tree Canopy Coverage Ordinances. The Urban Design section recommends the Planning Board adopt the findings of this report and approve DSP-19044, DDS-665, and AC-20005, subject to the conditions found in the staff report. The applicant is proposing 3 revisions, and staff has evaluated and is in full agreement, including a modification that will be presented by staff. This includes staff's presentation.
Thank you. Are there questions of Mr. Bush at this time? Commissioner Dorner.
So just on the photometric plan that you have there, I can't zoom in, it's way too blurry when I zoom in on the table as well as the map itself. So can you just walk us through what it is? The only thing I can glean out of there is there's like a 3,000 Kelvin lamp, which is fine because it's not actually like daylight amounts, but I can't tell anything else from the photometric plan.
Certainly. So when staff reviews a photometric plan, one of the main things that we look for is to ensure that adequate lighting is throughout the site, which this photometric plan does show. Another thing that we also look at is along the property line, that the foot candles, which are shown, you can see in the green and red possibly. We can maybe zoom in a little more. What we actually look for is that the foot candles do not exceed 0.1 foot candles. And that is true and consistent with this photometric plan. A 0.1 foot candle measurement ensures that there is no spillover onto the adjacent properties to the east, which is the existing employment park, and also to the north, those single-family dwellings that are there. Again, to the south, that is wooded property owned by Prince George's County government, and it is zoned open space.
Okay, so is the lighter, or I guess is the darker gray, is that the initial spillover that's at a higher amount, and then the white kind of area in there, which I guess it probably has like a value of 2 or something, or 0. Does that just show that the spillover doesn't get any farther than the darker gray?
Yes, well, the gray is the surface parking lot, if I'm
Okay.
seeing your illustration. So yes, so the gray is the surface parking lots proposed for each development pod. And so again, the foot candle measurements are the smaller numbers here, which I think I'm zooming in as much as I can here.
Yeah, I don't think you're going to be able to see them because I couldn't see them before and I tried to zoom in.
So the smaller numbers there throughout this illustration are actually what the measurement of the foot candles, which is how you measure photometry with lighting.
Okay, it might be easier in the future either having a higher resolution image so you can actually read the numbers, or doing a color gradient so I can see where it actually goes down so it doesn't go over there, because visually I can't tell anything from this.
Certainly, staff takes that into consideration.
Okay, thank you.
Are there any other questions of Mr. Bush at this time? Okay, Mr. Gingles.
Good morning, Madam Chairman.
Good morning.
Good morning, Madam Chairman, members of the board. For the record, Andre Gingles, an attorney with law offices in Laurel, Maryland. And kudos to Commissioner Dura on the 2020 look.
Thank you.
Like that. So first of all, I have Mr. Larry Cohen, who is the owner of Restaurant Depot. I actually have some affection for the company because my son, Colin Gingles, actually, who does chef work in Atlanta and Baltimore, actually got his own Restaurant Depot card. And every now and then I'm the beneficiary of him going there to shop and prepare the appropriate meals. So glad to see him come a little bit closer to the area, particularly where I live as well. But Mr. Cohen would like to just take a brief moment to introduce himself and tell you a little bit about the business, and then we'd like to go over those modifications that Mr. Bush spoke about.
Please identify yourself.
Hi,
And,
my name-
and you don't have to bend, just raise the microphone. Okay, there you
Much
go.
better, thank you.
Okay.
Hi, my name is Larry Cohen. I'm actually not the owner of Restaurant Depot. I am one of the 2 founders. I founded it with my brother-in-law. But years ago, we took in a larger partner called Jetro, and it's all one company now, and I'm the chief operating officer of Restaurant Depot. We opened our first location in 1990 in Queens, New York. We opened our second one as a joint venture with this company, Jetro, in 1995. And then 1997, they bought us, and it's all become one company.
We're in Queens, New York.
The first location was in Elmhurst, Queens. If you know Queens, there were two big gas tanks that were famous.
That's why she asked the question.
You know the Elmhurst gas tanks that were on the Long Island Expressway? We were right across the street from that, which was a big marking for us. And we're now currently located in Whitestone, off the Whitestone Expressway.
Okay, thank you.
Okay. So we currently operate 137 locations in 35 states. Our typical footprint is about 60,000 square foot. We cater to the small independent restaurant. We opened our first location in Queens where there's a lot of delis, bagel stores. And when we first opened, the chains were really inundating America, the restaurant chains, the Fridays, the Chili's, et cetera. And the small restaurants were really being forced out. And we had a small distribution center. We started a small distribution company, which my father started. And when I came in with my brother-in-law, we realized that they were really being pushed out because of the margins. The chains had 200 restaurants along the East Coast. They could buy better. They could get next-day delivery, et cetera. And we saw a niche for the small independent restaurant who really needed our help. So that was the beginning. That's how we began, where a small restaurant can come in and pick out exactly what they need, as opposed to calling a salesman, getting it delivered. And because they were so small, their orders were not that important. In the 90s, they actually did a study that the chains were 53% of the restaurant business and growing. And it's funny, about 5 years ago, they did a similar study, and independent restaurants are now over 50% and growing. And we think we're part of that. We've given them a place where they can come and they can pick out the size of steak they need to cover the plate. They can pick out, do they want smaller asparagus or bigger asparagus. We have all levels of beef, from the lesser grades that people will chop up and fry in cheesesteaks to we have our own Black Angus beef, which is really the highest quality, and I put it up against any Manhattan steakhouse. And so what we also do is we provide educational services for our customers. Again, the chains have groups of people who are food safety experts, et cetera. So we've done some of that to give our customers a way to learn and keep current, et cetera. So I'm not sure what else to tell you about it, other than, as I said, we have 137 locations. Where we've opened over and over, we see the small independent restaurant has a recurrence, has a revival. And again, because they have access to top quality food at low prices.
Thank you. Are there questions or comments?
Any questions?
Thank you.
All right, thank you very much.
Okay, thank
I actually will mention that we've been looking at the site for a while, and we really think it would be a great site for us. Okay. And one other thought is that there are a lot of big box retailers out there. We're friendly with them. They do a great job. But one of the big criticisms for many of them is that when they open, some of the small businesses go out of business. When we open, the small businesses thrive. And I think we're very proud of that fact. So thank you for your time.
Just one quick question. Do you have other sites in Prince George's County already?
Yeah, we have one in Capitol Heights, Maryland.
Okay.
Just opened recently, right?
Yeah, a couple of years now.
Okay.
Thank you.
And Commissioner Dorner, did you have a question? No? Okay, sorry.
Okay,
thank you.
everyone.
All right, Mr. Gingles.
Madam Chairman, if that would be applicants Exhibit 1.
Okay.
Or 1. Is Mr. Bush?
Okay, so we have received applicants Exhibit number 1, which is consists of the proposed revised conditions, or revisions to conditions, and we'll accept that into the record as identified. Thank you.
And do you also have in front of you?
On
this-
Green. Okay.
I'm sorry, do you also have in front of you, can I just also give you staff Exhibit 1 also?
So we have applicants Exhibit 1, and then you're giving us staff Exhibit number 1 now?
Yeah.
Okay.
Staff's revision to my revision.
Of course.
Yes, of course.
Thank you. Okay, so we're going to mark your, the staff's Exhibit number 1, which is the revised Condition 1G, and that will be staff, will accept it into the record as identified.
So essentially, the first revision is to remove 1B, which dealt with some artwork, as we've sort of explained to staff, we've actually gone through and revised the building, and we think the architecture that we've put on the building and the revisions that we've made are satisfactory as the staff. The second revision had to do with a condition that was sort of forcing a connection between those two parcels. Several different issues, but as staff, you can see by the revision that they've done that's kind of in the bold lines, it's really to have the connection there so that if there becomes a necessary to move between the parcels. We didn't want it as an open driveway, concerned about cars moving from in between the loading areas between the two buildings and actually causing particular hazards as a result of that. We think as long as we have the sort of alternative that they've placed there, that we can have that connection there, and therefore if it becomes necessary, whether it's for emergency purposes or along the road or actual emergency in terms of public safety, then they'll be able to move between the two parcels. And the last revision, which is on the back page there, is to number 3, simply to be able to get the rough grading permit. We are a little bit behind in the schedule. We'd like to start some of that rough grading while we are moving forward with the rest of the permit plans, and therefore that has been changed. We initially said first fine grading permit. As we discussed this with staff, we just thought it was clear, or they thought it was clear, and we concur, that we just changed those to say rough grading permit.
Okay, so, Mr. Bush, with your staff exhibit number 1, you're okay with the conditions, right? Okay.
Yes, staff is in support
Okay.
of revised conditions.
Okay.
The only other thing we would ask, Madam Chairman, is that the findings that are currently in the staff
That
report
relate
be
to-
revised to reflect.
Correct, to correspond to these, okay?
Yes.
Okay. And Mr. Bush and our legal counsel will ensure that that's the case, okay? Before it comes back to us. Okay, are there any other questions? Was there anyone else who wished to speak? Is there a motion?
Madam Chair, that we approve DSP dash 19044, Type 2 Tree Conservation Plan, TCP 2-029-2019, and alternative compliance AC dash 20005 for Park Place, including the variances to sections 25, 122B1G, and section 27, 465A, as well as an approval of DDS 6-655 to allow standard parking places to be 9 feet by 18 feet, as well as the associated staff findings and conditions as outlined in the staff report, as modified by applicant Exhibit 1, and as further modified by staff Exhibit 1 as well.
Second.
We have a motion and a second, and I would just add to that, and findings, the findings to correspond with the changes to the conditions, and we'll see that too. Is there any additional discussion?
So I'll just add to the discussion as well. Thank you for supporting the county. One of the things that we like to see is to have support of local businesses, small businesses, to help people thrive and make their way through. So I think particularly for the restaurant scene, that's actually becoming quite a bit here. We have some food courts that have opened up that are local businesses that started with food trucks that people find they're getting brick and mortar and are being successful. And it's help of supply chains as well that's really big and important. So thank you for the support.
Yeah, I think we'd like to echo those sentiments as well. And also, and not only does it help the small businesses, but it provides choices for our residents. So all in favor indicate by saying aye.
Aye.
Opposed, the ayes have it.
And it helps get kids out of houses.
Helps get kids out.
Got mine
Touche. Okay. May I take this moment to say I was remiss in my announcements earlier in not acknowledging and commending the Planning Department, but particularly the Black History Month, the Planning Department's Black History Month Committee, and the Diversity Council as well for putting on a wonderful Black History Month program for the Planning Department yesterday. So I just wanted to say kudos to everybody who was part and parcel of that. So thank you. And that includes you, Ryan, too. Okay.
Thank you, Mr. Gannon.
All right, so thank you so much. And then we have item 3A. Okay.
Good morning, Madam Chair. For the record, Raina Hightower, Intergovernmental Affairs Coordinator. Today, I would like to present a couple of bills to you. The first one being CB6 2020, which amends the zoning ordinance regulations for expedited transit-oriented development to require developments of multi-story buildings as part of a development project. Staff believes the language should be clarified in the bill to avoid potential loopholes where a building includes stories below grade or above grade stories for parking only. Staff recommends that at least one building within a development project include 2 or more stories of above grade habitable or leasable space. This concludes staff's presentation on this bill. We recommend that the planning board vote to support CB6 2020 with the amendment of adding language that requires all multi-story buildings to be built above grade.
Questions? Motion?
Move approval as recommended by staff.
Second.
We have a motion and a second. Is there any discussion? All in favor?
Aye.
Opposed? The ayes have it.
The next bill we have is Council Bill 7, 2020, which adds a new definition for market hall to the zoning ordinance and permits the use in the I-1 zone under certain circumstances. It also creates a new footnote which exempts market halls located in municipalities from off-street parking and loading regulations, except for when handicap parking is required. Staff believes this is for a specific project or property, and we want to remind the District Council of the county map amendment that's coming up in November 2020 to help allow the adopted new zoning ordinance to become effect. There's no reasoning for why parking regulations are exempt within municipalities. Staff recommends that the planning board vote to oppose CB 7 2020. That concludes staff's presentation.
Move to approve the vote or the disapproval of the recommendation to disapprove, but in doing so, please provide the recommendation, the reasons for it, because I think that's something that we've asked for as we oppose different kinds of projects. We want to tell the district council why. That way we're communicating with them and they understand that in November, we're going to have this in there, and that we don't encourage to have text amendments for single site uses, because spot zoning is not a very good practice.
We do that. We put that in the letter, because I signed the letter to the council, so we always put the reasoning in there.
Second.
Okay. That was a motion, and was that, yours was a motion, right?
Yeah.
Okay, and a second, and a second. Okay. Okay, we have a motion and a second. Is there any discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it. You know, I was thinking about that, but we can talk a little more because all of our municipalities are not the same, and some there's limited parking and you know, and narrow streets, and I don't know. It's just something to think about. Okay.
So the site that they're talking about has tons of parking.
Yeah, okay.
It's a vacant warehouse
Okay.
district around there that has basically nobody there during the days. It has by far well adequate parking around the vicinity.
Okay, thank you.
Thank you.
Okay. Oh, you have more. Okay, let's go.
One more that there are 3 bills in one.
Okay.
And the planning board voted on them last year to support them with amendments. And we would like to recommend, again, supporting the bills with amendments. We'd also added a small amendment to ask that the current bill be amended to permit multifamily developments to be permitted by right in a multifamily zone. The bill has.
I didn't hear the last statement. By what?
We're recommending an additional amendment.
Okay.
To permit multifamily development in the R10, not subject to a footnote, because the R10 zone is a multifamily zone. We also recommend the removal of the bedroom percentage language from the bill and the entire zoning ordinance, because those regulations were deleted last year but the use tables were not amended. So staff recommends that the planning board vote to support CB 9, 10, and 12, consistent with your positions last year.
Okay. Questions? Motion?
Move to support with the staff's recommendation.
Second.
We have a motion and a second. Is there any discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it. That was it for you?
That's,
Okay, Mr. Hunt. Is there any additional business to come before planning board today?
Madam Chair, that's all before the board today.
Well, thank you. Planning board is adjourned. This was a nice reprieve from last week.
Yes, yes.
You could balance it out
Yes,
better,
yes.
that video.
Ah.